not at the ID at the time when they were taken. My concern is that this matter was not dealt with in the normal way. Ordinarily, even a matter received by the ID herself would be referred to me or one of the DDPP colleagues or the chiefs to evaluate whether it falls within the mandate and to advise her before she takes a decision. Here, the ID received the matter and it appears took the decision on it herself. The operational manual, especially as it relates to case intake, was not fully operationalized. Before the ID's testimony at the ad hoc commission, there were very few Section 27 referrals that came through. If they did come through, they would be received by her office. I specifically recall the speaker matter, where she called a meeting about the matter and instructed that it be considered and appointed a team to deal with it. Whereas with the CI matter, I only learned of them when they were already authorized. They were not discussed with me before they were authorized. I did not see Honorable Adams' Section 27 referral either. Even when Advocate Surunya asked me about it, I informed him that I did not see it. By way of context, on referrals generally, historically, most of our matters flowed from the Zondo Commission, Mpati Commission, and the Nugent Commission, in respect of which the former ID had already granted sweeping authorizations under the presidential proclamation establishing the ID. Attached is the presidential proclamation marked MS4. There was therefore no need for Section 27 referral. As per practice, most matters are referred to the DDPPs, who then prepare a submission to the ID for authorization. Most matters in IDEC space were authorized as a result of the presidential proclamation. The table below illustrates this point. So the table shows that the security cluster and commission matters are 137 in number, which represent 88% of matters that are within IDEC. And the other IDEC mandate, those are the matters that would have come either from other law enforcement agencies or through Section 27 referral. They are 18 in number, representing only 12% of the matters that came to IDEC.
Mr. Sisi.
A matter, sorry, Ms. Paul. We now know that IDEC received a Medicare 24 referral. Where does it fall in your table?
It will fall under the IDEC matters, IDEC mandate matters.
Mr. Sisoko, you say that very few Section 27 referrals. From previous witnesses, what we heard was that there was only one other referral prior to this. Is that your recollection? And that would have been the speaker matter. And that the one that comes under Medicare would have been the third.
No, as I said, I'm working from our register. This statistical information comes from the register. As I said, that these IDEC mandate matters, which are 18, would be matters that either come from law enforcement, which they refer to us, or they come as a result of Section 27 referral. The ones that are Section 27 referral that I can think of right away is like your speaker matter, your Project Golden, and which one am I missing now? Yes, the Medicare one.
Does the register delineate with that number of 18 which ones were Section 27 referrals and which ones emanated from other law enforcement agencies?
No, the register will show that these matters are the matters that came after those presidential proclamation matters, which are
Lately, seems your career depends on how fast you adopt AI. Want to know my secret? It's simple. I work in ClickUp. Your team projects, messages, and files are kept in one workspace. So the work is visible and the priorities are clear. And ClickUp AI has 100% context of your work, so it's an expert for your company and your workflows. When your workspace is this smart, you don't have to work harder to get ahead.
Excuse me?
and the CI
Oh,
matter.
CI, yes, of course. All right, thank you. You can proceed with paragraph 44.
After the ID gave public testimony at the ad hoc committee, the volume of complaints increased. My own practice on receiving a complaint, whether a Section 27 referral or an email from the spokesperson, Mr. Henry Matumani, is to assess whether it falls within mandate. If it plainly does not, I respond or refer it out if the position is unclear. If the position is unclear, I meet the complainant to establish whether it falls within the mandate. And if it does not, I refer it to the appropriate agency. This would be done by way of a memo to the ID with recommendations. Of the matters I have received, I recommended only one for authorization. Attached MS5 is the register of matters that went through my office or I became aware of. Of the 27 matters that were recorded in the register, 13 of them were received by me. I only recommended one for authorization. Chief Boy received 5 matters and Chief Perumal received 10 matters. At the time when the CI matters were authorized, I was on duty and no one was acting in my position. I went on sick leave on the 10th of November after I was kidnapped. Then Chief Perumal was appointed to act in my position until I returned to work on the 13th of January 2026.
Just to understand the matters that Chief Boy authorized, when would that have been? My apologies,
Some of them would have been when, I think most of them is when I was on leave, if my memory serves me well. I think the register will be able to indicate, because it indicates when they were received. The MS5 would show when they were received, either by me or Chief Perumal or Chief Boy, and what was done with those matters.
All right, thank you.
Can I just ask, what informs the decision whether matters get referred? They don't fall in your mandate, I accept that, if that is the decision, or the determination, but then you get to refer to other law enforcement. What informs referring or not referring matters to IPID? Because IPID deals with police, corruption, and similar. Is there a principal position that matters never go to IPID? And I ask because in the evidence so far about the crime intelligence matters, there are matters where it looks like on the face of it, until a final determination, that this could have been referred to IPID, because from what one understands of IPID's mandate, that particular issue may well have fallen within their mandate. Is there a principled position within IDEC not to refer matters to IPID?
Chair and Commissioners, the decision is based on the assessment. As we discussed before, that when it has to engage the IDEC mandate, it must meet the threshold of complex corruption or commercial and so forth, high profile. So even if it may involve members of the police, but if it meets that threshold, then it engages the IDEC mandate. However, if it does not, that's where then you have to refer the matter to those law enforcement agencies. As you'd see from the register, how I dealt with most of these matters. Some of these complaints, people complain that decisions were taken in the NPA, they were not happy with it. And when I assessed that, I realized that it does not engage our mandate. In fact, they need to do representation or things like that. Or some of the matters, people will say they went to IPID, they're not happy with IPID. You know, I would refer them to the management of IPID, that they be assisted there, or DPCI for that matter. I would refer them to the head of DPCI, exactly to avoid a situation where we take on the matter that are already in the space of other law enforcement agencies.
Let me ask more directly. A case that has been presented before us. You have the General Lushaba loss of laptop story, and the IDEC gets involved in that matter, and it seems that IDEC is investigating and ultimately got him into court, is investigating what happened subsequent to the loss of the laptop, how that was handled. Someone supposed to have lied, a police officer at a police station, according to the evidence that we've had. On the face of it, it would seem to me that it may well have been a typical IPID matter to investigate, and yet it is a matter that IDEC fully investigates and prosecute. Can you explain how, can you answer my question with reference to that kind of question, to those kind of facts, that you have a case that looks like an IPID case and yet IDEC investigated it? What makes it fall within the mandate?
True, Chair, on the face of it, it looks like an IPID mandate matter. But at least from the explanation that I was given was that there was quite a number of actions that showed corruption on the part of members who were involved in terms of hiding the true nature of what had happened, manipulating the dockets that were opened, and giving gratification to some of the investigators who were supposed to conduct that investigators with a promotion and so forth. That is the explanation that was given in one of those briefings.
If you absent, and I'm really asking because I want to understand whether some of the problems that we have become aware of, are they structural problems of competing jurisdictions, and therefore the one body ends up dealing with matters that they shouldn't. So if you exclude the gratification issue, yeah, you received a complaint. That's how it's, as I understand it. Mr. Adams filed a complaint and said, General Lushaba lost his computer and there was a cover-up. That's how I've understood it to be, that there was a cover-up, and the cover-up goes to even his superior, even General Kumalo, even though General Kumalo was not his superior at the time. But the cover-up goes to General Kumalo, but also now someone took an affidavit at a police station and they misrepresented some things. Forget gratification for now. On the facts that I'm putting to you, would you still have said this is an IDEC matter?
If there was no issue of gratification and alleged corruption, it would definitely won't fall within the mandate.
Okay. Thank you.
Mr. Soko, you can continue with your affidavit. We are now dealing with the conflict between Advocate Ramsamy and Chief Perumal, paragraph 46 of your statement.
The conflict, the ID called me into a meeting to help resolve a conflict between Chief Perumal and Advocate Trushanta Ramsamy. As I understood it, the conflict concerned the approach to the case. Advocate Ramsamy, as a prosecutor, had taken a particular legal view with which Chief Perumal did not agree. The meeting was resolved on the basis that the parties should listen to one another, consistent with IDEC prosecutor-led model, and that the prosecutor is ultimately the person who must take the decision on the matter. This is how the issue was resolved. I must, however, indicate that in subsequent meetings where I was called into or brought to my attention, it appeared that these conflicts continued. And Advocate Ramsamy was concerned that as a prosecutor, her views seemed to be overruled by those of Chief Perumal, and that the ID seemed to take more the side of Chief Perumal than her side.
Do you recall how many other meetings related to conflicts between the two took place?
I honestly cannot recall. They were varied. Sometimes Chief Perumal would come to me. Sometimes Advocate Ramsamy would come to me. Would have a discussion with the ID, you know. So they were varied. I think because of that and the fact that Chief Perumal was not happy with Advocate Ramsamy, ultimately she was also removed from the matters.
Did you not supervise Chief Perumal's work? I mean, if there was conflict between him and the lead prosecutor in the matter, because he reported to you, was that not an opportunity to then look at what he has done and supervise him and provide guidance?
Chair, we would have a discussion about these conflicts, as I said. And in the nature of how our project works, and it's also in the manual, that all the discussions in relation to the project must actually happen at the level of the team, so that even when there are these disputes, the matters would be dealt with at the team level. So where you would have opinions of the entire team, in terms of how the matter should be progressed, what needs to be done, what not needs to be done. And the deputy responsible for the matter would then take the ultimate decision if there is no amicable solution within the team. In this situation, unfortunately, the lead, instead of the DDPP, was the ID. So she would then take the ultimate decision on how the matter would proceed. So she would then overrule the opinions of junior prosecutors like Advocate Ramsamy to say, this is how I want it to go. I agree with Chief Perumal or whatever the case may be. So that is how, in this specific matter, it turned out.
So the head of investigations is excluded from all of that. You don't play a part at all.
That decision-making is that of the ID. I would not be included in that decision-making. We can have a discussion, but you ultimately take a decision. This is how it is going to happen, and it would happen that way.
But you did participate sort of in the lead up to the final decision about what is to happen, i.e. you mediated this meeting and then you indicated that there were several other meetings where you had to talk to either.
Yes. As I said, that it would sort of be a complaints session, Chief Perumal come to me to complain. Advocate Ramsamy has made a submission that there is no case and all that, and he believes there's a case, those kind of things, So when we discuss these matters and trying to find out where the fault line lies, you have people who've got strong opinions about these matters, and the ID would then take a decision to say, this is how it must be done, and it ultimately will be done that way. So that is why the decision to proceed the way these matters were proceeded with, the decision to enroll, all these decisions were done by the ID.
Thank you. We can then proceed to the next topic, which is the disciplinary and league matter concerning Mr. Rapesu. That's at paragraph 47 of your affidavit.
Yeah. The last occasion on which I was involved arose when the ID convened a meeting and informed us that she had received a call from Mr. Nkabinde. Mr. Nkabinde alleged that Mr. Rapesu had telephoned him and informed him that IDEC was conducting an investigation against him and that Mr. Brian Badiache was the investigator. In other words, Mr. Rapesu had leaked information.
Yes. Funny how quickly life opens up when you stop saying maybe. Big Fred.
Where'd you get the call? I'll show you.
Ooh. Auto Trader, drive possibility.
By the ID to refer the matter to our Security Management Services, SMS, to arrange a polygraph. The SMS began the process by referring the request to the State Security Agency, but then reverted to us to say the State Security Agency does not conduct polygraph tests for internal disciplinary matters, and that if IDEC wished to have one conducted, it would have to procure the services itself. That was never achieved, and the matter was left there. Mr. Rapesu continued to ask about progress, and I gave him what I knew through his supervisor. I was later told that he had lodged the grievance about the issue. I subsequently learned that the grievance had been dismissed on the grounds of a time lapse. At the time I was asked to facilitate the polygraph, I received a report from one of our investigators, Mr. Ndumbalo, who had been tasked to investigate the alleged leak. The report recorded that Mr. Nkabinde was refusing to provide a sworn statement about the alleged leak. The ID wrote a letter to Mr. Nkabinde calling on him to provide a statement, and if he's not willing, indicate so in writing. Attached is a letter from the ID marked MS6. Mr. Nkabinde responded to the ID letter with the email dated 27 March 2025. The email is attached as MS7. The ID further wrote to the advisor to the minister, Advocate Pikoli, raising frustration about Mr. Nkabinde's failure to provide a statement. The letter is attached as MS8. Mr. Mbalo expressed that Mr. Rapesu would have leaked the information. Alternatively, that Mr. Binang would have done so, allegedly because he learned that I revealed information to Mr. Binang. Attached is the report by Mr. Mbalo marked MS9. On my reading of the report, I was convinced that it insinuated that I'm also a suspect for leaking the information. So when communicating with SMS, I advised them that I was also volunteering to be subjected to polygraph test based on paragraph 4.2 of the findings of the report. Attached is the email dated 25 June 2025 to SMS marked MS10 communicating same. The obvious difficulty with that report is that the allegation was that ID herself received the call from Mr. Nkabinde. There's no indication in the report that a statement was obtained from the ID about the allegations. And to obtain the records of the alleged call to her, nor were the records of Mr. Rapesu, Mr. Binang, or me obtained. I recently learned a further step that I regard as irregular. While I was on sick leave in January 2026, an investigation was authorized within IDEC in terms of Section 2813 of the NPA Act against Mr. Rapesu for leaking information. The authorization was for the contravention of Section 41(6) of the NPA Act. The application memo indicates that it is from Chief Perumal, even though his signature is not in the memo, and it is authorized by the ID. Attached marked MS11 is the application for authorization. This offense is definitely not within the IDEC mandate and should not have been authorized in IDEC. I regard this as odd for 4 reasons. First, Section 41(6) investigation of this kind is not an IDEC mandate. Second, the ID herself received the initial complaint from Mr. Nkabinde. Would appear to be conflicted in authorizing an investigation arising from it.
She's actually the complainant because
Yes.
Mr. Nkabinde is not the complainant.
Yes, yes.
So in a 41(6), the ID is the complainant.
Yes, yes. So that's why I'm raising that. Third, Chief Perumal, as a witness in the investigation, cannot apply for authorization. Fourth, so maybe to explain this, when the ID called that meeting, she indicated that when she received the call, she was with Chief Perumal and Chief Investigator Pariachi. So they had that call, or the conversation between her and Nkabinde. which makes them witnesses in this investigation. So that's why I'm saying that Chief Perumal, as a witness in that investigation, cannot apply for the authorization. Fourth,
Had the ID put the call on speaker, or how would they have heard?
yes, that's what she indicated.
All right, thank you.
Fourth, there is no indication that the former IPID officials who are alleged to have attended a meeting with me were approached for their statement. When I returned from leave, Chief Perumal briefed me on the referrals he had dealt with in my absence. So those referrals are those that will be on MS5 that he had dealt with, but he did not mention this one. As I was preparing my affidavit for the commission, I called the IO, Mr. Mbalo, to inquire about this matter. He confirmed that the investigation was authorized and that he was going to recommend that the investigation be closed as there is no evidence to implicate Mr. Rapeso in wrongdoing. I called for the file and established that there is a statement from Mr. Nkabinde dated 27 November 2025. Mr. Nkabinde, who had refused to provide a statement, now deposed to an affidavit which expanded the allegation to implicate me, asserting in substance that on learning of his appointment as Chief of Staff, I had convened a meeting and asked investigators to investigate him and to find anything they could against him. I deny that allegation. Mr. Nkabinde's statement is attached and marked MS-12. What I find odd is that the colleagues who are alleged to have been in a meeting with me are not approached for their statement to corroborate this allegation. I also established that only a subpoena for the cell phone records of Mr. Nkabinde and Rapeso were requested. They were analyzed by Digital Forensics South Africa, and their report confirmed that there is no record of the calls either from Mr. Rapeso's phone or Mr. Nkabinde's phone. No cell phone records were obtained for the ID phone to confirm that the call was indeed made to her.
Thank you. I think we can then move on to the next section. Why I did not impose myself into these matters.
I've been asked why, given my position and the leadership role I ordinarily play, I did not raise concerns at the time or ask to be included in these matters. The answer lies partly in my own history. During my time at IPID, I was involved in serious conflicts. I stood my ground and I paid a heavy price for it. I was suspended in 2015 and subjected to a disciplinary process and criminally charged, which I regarded as unlawful. The charges related to IPID report concerning the rendition of Zimbabwean nationals. In August 2016, I was dismissed in absentia after being found guilty of gross misconduct at a time when I was hospitalized for depression. My request for a postponement had been refused, and I never gave evidence in my own defense. Following the Constitutional Court finding that the suspension of the then Executive Director, Mr. McBride, was unlawful, he was reinstated to his position. I also challenged my dismissal through the Bargaining Council and was reinstated. I was suspended again in March 2020 by an incoming acting head of IPID, and again had approached the Bargaining Council. I was then reinstated. I testified before the Zondo Commission about police corruption and about political interference that I believe lay behind my suspension. These experiences were costly to me, personally and financially, and to my family. I'm 61 years old, near the end of my career. When I found myself excluded from the CI matters, I made a deliberate decision not to force my way in. I took the view that if the ID did not involve me, it was not because he did not want me involved. No, it was because he did not want me involved, and I respected that. There is, in any event, a practice at IDEC that if one is not on a matter, one does not seek to know its details, and there is a related principle of neutrality. I let the matter be, and I did not ask ID why she did not involve me. There was also a further, more recent consideration. On the 7th November 2025, I was kidnapped while driving home. I was assaulted and robbed. My attackers took my state-issued laptop, cell phones, and abandoned me near Rabridge in the early hours of the 8th November. I reported the matter to the police and received medical treatment. While I cannot say with certainty if this event is related to my work, however, there were two distinct occurrences during the robbery that makes me suspicious. First, the kidnappers demanded a firearm. When I told them I did not have one, they assaulted me so much as if they knew I should have one. Second, when they took all the gadgets, laptop, cell phone, tablets, Samsung watch, they asked for PIN numbers and passwords of all these gadgets. However, on the work laptop, they specifically demanded that I write the password on one of the kidnappers' phone, and they took the laptop to a house. They only did this with the laptop. This occurred against a backdrop of public allegations against IDEC and its leadership, and of threats directed at the unit following the CI arrest. That experience had affected how I approached my work and my own safety. In the circumstances, rather than insert myself into these matters from which I had been excluded, I confined myself to assisting on discrete issues on which I was asked to assist, and to advising those members of the team who approached me for guidance. I otherwise left the ID as the head of the unit and my supervisor to deal with these matters as she saw fit. I wish to make one matter clear. I do not say that there was no case to be investigated against CI officials. My concern is not with whether there was a case, but with the manner in which these matters were handled, and in particular with the departure from the established intake and investigation process. Even where there is a case to answer, it must be dealt with in accordance with the process. And where the process is not followed, the integrity of the outcome is placed at risk.
Before you go to the conclusion, did you play any part in IDEC's presentation before the ad hoc committee?
No, I did not, Commissioner.
Because when the former ID went there, she was not going there in an individual capacity. She was going there representing IDEC. So you are head of operations at IDEC. Did you not assist at all with the presentation?
Not at all.
Not at all. And then after the 6 July 2025 media conference by General Mkhwanazi, serious allegations were made against IDEC. I'm sure you are aware of that.
That's correct.
Did you not, as head of operations, look within to see if there's nothing wrong that IDEC did so that you can assist the ID if she needs to account to the nation or to Parliament?
There were meetings and discussions about those revelations by General Mkwanas. And in those meetings, they were dismissed as a counter to the investigations that had happened against the CI generals.
And then internally, Advocate Serunye raised two issues. One was the Section 27 referral affidavit was not there. The investigators did not have it. The prosecutors did not have it. So that was the one issue. The second issue was the two CI matters, the Mokwele matter and the Lushaba matter. There were no DDPPs who were leading those investigations. And he raised those issues as serious concerns. And as far as I understand, you were copied in that correspondence. Why did you not do anything? If he says the Section 27 is not there, it has not been provided. And secondly, these investigations were supposed to be led by DDPPs. They were being led by junior advocates at IDEC. Did you not say anything? Did you not intervene? Did you not raise these similar issues with the ID? Did you just let them?
While you're watching this Monday.com ad, Emma clicked the star and Monday Sidekick just planned her entire campaign, scheduled every milestone, and briefed the team. Bring those leads in, Emma. Monday Sidekick, AI you'll love to use. Start a free trial today at Monday.com.
And the ID was not even happy about those things being raised, because as I understood at the time, she felt that these matters were properly within IDEC. And I think she sort of took umbrage why those issues were raised. So in those meetings, I think the issue was, a decision has been taken, matter is authorized, it's going to proceed as she's directed.
And then the last one, in this commission, your investigators, Mr. Padiaki and Mr. Chief Perumal, have been accused of what on the face of it is serious misconduct that may well amount to fraud. The commission has not made findings one way or the other because we must hear all sides. But the allegations are that they created affidavits many months after, and then they backdated the affidavits to create the impression that those affidavits were deposed to on the 6th of January 2025 in relation to Mr. Adams's supplementary affidavits, and then in relation to the Section 27 affidavit. The allegation is that the affidavit that has been provided to the commission and the one that we as commissioners have been looking at was only created after October 2025. And it could not have existed in November 2024 when Mr. Adams made the referral to IDEC. Now you as head of operations and head of investigations, when you hear allegations like those, did you make inquiries internally to find out what the position is? And if the commission has been misled and has been provided fraudulent documents?
Chair, my recollection is I heard of these allegations when these matters were ventilated here at the commission. I think Mr. Rapesu would have indicated that he suspects there is something wrong that would have happened with the Section 27. And if I remember his words was, but the truth will come out. So, I remember speaking with Chief Perumal, if he knows anything about this. And then he says, no, there's nothing like that. Everything, it's on board. And I took his word for it.
Lastly, and it's a question Chair asked, because you are the head of investigations, is it common, is it usual within IDEC that an investigator can start an investigation and conclude the investigation without having seen the Section 27 referral? Because Mr. Padiaki told us that that's what happened in this case. He never saw the Section 27 referral.
Chair, in terms of our processes, and the manual also speaks to that, when a matter is authorized and the project manager convenes a project meeting with all stakeholders, including the DDPP, all information relating to that matter is shared and discussed within the team. It is an anomaly for those documents not to be shared within the team. It is clear that on this matter, there was exception to the rules.
Did it also have formed part of the application for a warrant of arrest, the Section 27 affidavit? So when IDEC applies for a warrant, should the Section 27 have been attached to the affidavit that was placed before the court? How does it work in practice?
In practice, the investigating officer will draft an affidavit, basically outlining the investigation conducted and the offenses that,
because
that are alleged to have been committed.
Sorry to interrupt you. Because the starting point is the Section 27 referral, does he attach it to the affidavit? When
No, in practice
he
it's
doesn't
not.
do that.
In practice, it's not.
But it forms part of the docket.
In practice, it's not.
So in practice, it does not form part of the docket. You
No,
don't even share it with the accused.
No, it is part of correspondence, internal correspondence, but it's not attached to the docket.
And when they ask for it because they want to challenge IDEC's jurisdiction or IDEC's mandate, how do you deal with that?
Well, when they ask for it, in my experience is that it has been provided when they had asked for it.
So, Mr. Sisoko, when a docket is opened or when an inquiry is opened, doesn't the Section 27 become the A1 statement? And then it can be supplemented if there's anything further to add to the affidavit. How does it work at the start of the investigation? Assume that the investigation has been authorized, either in terms of 28.1 or 28.13, and then a docket or an inquiry is opened. Shouldn't the Section 27 affidavit be the A1 statement?
In practice, Chair and Commissioners, the Section 27 referral is treated differently. When an investigation starts, when it's authorized, then the complainant is approached for an A1 statement, and a full comprehensive A1 statement, which would address all the elements of the offense, is then obtained. And that is what is used as the A1, not the Section 27.
Where does one find that? Is that in the manual or is it your interpretation?
It's the practice.
But where does one find that? Where is it recorded that that's the practice?
I'm not sure if we record it like that in the manual. I must be honest. I'm not sure if we do that. I think the manual states the processes that must be followed, but it does not specifically say what happens in relation to Section 27 or an A1 statement, because it's more of an investigative operational issue that investigators do.
And the reason we are asking this is because Mr. Serunia, Peter Serunia, and Ms. Ramsamy, they have testified in this commission that, and I hope I'm not confusing their evidence and the transcript will bear that out, but they said the Section 27 affidavit becomes the A1 statement, and then any further statement obtained from a witness supplements the Section 27. So the Section 27 is not an internal document. It is the genesis of the investigation. It is the affidavit that must set out what offense is being reported and what offense must be investigated, so that what the investigator looks at and what guides the investigating officer is in fact that affidavit.
Chair, I won't dispute that it may happen in other matters, that, you know, the Section 27 may have been included as an A1, you know. But I'm talking in generality what I know would have happened in most of the matters.
But because IDEC has not had that many Section 27s, you
Yes.
said so yourself,
Yes.
most of your matters are from the commissions,
Yes.
and there was that general authorization from the former ID. Don't you think this is something that should be clarified in the manuals?
Yes, certainly, Chair. I mean, this experience with the Commission, it's a lot of lessons learned for us. We already having a discussion internally about IDEC reset and how we improve our operations and including our manual, so that we are all clear in terms of processes, because this process has shown the weaknesses within the organization that really need urgent attention.
And these weaknesses are serious because they can lead to systematic failure.
It is
they
true.
can impact not just IDEC, but other law enforcement agencies, as you have seen with crime intelligence and SAPS.
That is true, Commissioner. Lessons learned.
Thank you.
Can I? Can I just check? You say in paragraph 59 that there is a practice in IDEC that if you are not involved in a matter, you don't seek to know its details, and this relates to the principle of being neutral. But surely that position in practice does not apply to the ID.
Yes, it does. It does not, Commissioner, because she's the ultimate person that takes decision on all these matters. A matter cannot be enrolled without her approving that. So every decision of this nature, it is taken by the ID.
But then by same, well, not same, you are head of investigations. It seems to me you should know what's happening in investigations.
Yes.
So that rule, if it's a rule in the workplace, should not be applying to head of investigations, because you need to be able to speak to the investigations that are happening in your organization.
That is correct, Commissioner. And in most matters, that's what had happened.
Yes.
As I said, this was an exception.
So in a properly working IDEC, a person in your position who is head of investigations is supposed to know and be involved with investigation. When I say involved, I don't mean you run and do the investigations,
Yes.
but you, because you're the overseer
Yes.
of all the investigators and of investigation, so you should know this.
That is correct, Commissioner.
Okay. Therefore, it must mean I'm trying to determine whether it's this a person problem that you ended up in this position where you don't know about investigations that are happening because they're being directed by the ID and who chooses Mr. Perumal, Mr. Pareachi, and others. Is it a problem that a different head of investigation would have been correct to say, I'm head of investigations and I will not be excluded from investigations? Or it's a misunderstanding of your role by both you and the ID that you are also subject to that rule of practice that you don't need to know what's happening in matters. I think put simply, is this a structural problem? Is it we happen to have the wrong people in the positions. We have the wrong ID in the form of Ms. Johnson, who did things the way that she did and excluded you, or we had or we had a wrong head of investigations who didn't assert his role and position when he gets excluded. Can you just say which one it is? And the question is important because, at least from where I'm sitting, because among the things that the Commission is required to do is to make recommendations, including recommendations about what improvements, changes need to be done to the organization. So we are going to have to grapple with how did IDEC land where it is today? Is it a structural problem? Is it that whoever employed Ms. Johnson just made a bad decision? Whoever employed Mr. Sissoko made a bad decision? You understand what I'm saying? What I'm asking you. Can you just comment to that?
Chair, the fact of the matter is, in this particular instance, rules were not followed. And I took a decision at that point in time, as I explained in my affidavit, based on my personal history. I take full responsibility that I should have acted differently. But at the time, for me, it was the right decision to take, given the considerations that I've said to the Commission.
I understand, and thank you for that answer. It's trying to understand whether, what's behind my question, whether in terms of your contract of employment, which sets out what your job is, you could have asserted to the ID, even if she didn't like it, you could have said, there is no investigation that will happen that I don't know anything about. Does your contract, the terms of your contract, give you that kind of standing, or it's a problem in the contract because maybe she still gets to make decisions finally about investigations? I'm trying to understand that. So I'm trying not to make it personal.
performance, what do you call them, which you sign with your boss, undertaking that you are going to perform in accordance with, and then, as I understand it, there's itemization of all, of everything that you undertake, you are going to do during that year. Am I correct that there is such a thing? What is it called?
That is correct. The performance agreement.
Yes. Now, I'm adding to what Commissioner Baloyi says, which is a reference to the employment contract itself, and I'm saying there's also this performance agreement. Would what you are required to do not also be, it would obviously be included in that, and would it cover what Commissioner Baloyi is raising, and if it would, what would you be assessed on if not on that? That is what it covers, which includes the issues that Commissioner Baloyi is raising. At the end of the year, how do you get assessed if you've not said, now if you do not allow me to do A, B, C, D, how am I going to be assessed at the end of the year? So basically, that contract would require of you to raise the issues that Commissioner Baloyi is referring to. Now, can you please respond? With all of that in mind, can you please respond to Commissioner Baloyi's question?
Thanks, Chair. My performance agreement provides that I must advise the ID. As I've indicated that these matters were discussed and should take a particular position. I understand the concerns, and in hindsight, maybe I should have taken this issue even further and not let it be as I did. But that's what, to me, at that point in time, seemed right to do. As I said, that maybe I should have acted differently by raising this issue at a higher level, so that what now has been ventilated here could have been stopped. I do, however, I am, however, not sure if it would have made any difference.
Sorry, you may carry on.
No, I was saying that I'm not sure, however, if it would have made any difference.
You say you're not sure because the ID is the person that she was, or what? Because you see, you speak of, you say your contract says you advise the ID. The next question is, well, what does that mean in fact? You advise her on investigations that your people are doing and what they put together as it before she makes a decision. Does advising mean that you say to her, on this investigation, there's no case? She ultimately, gets to sign off on the next steps. But what does advising her entail?
Advising the ID, it means advising her on all operational issues. Where matters are under investigation, what are the challenges, what needs to be done. Most of the time, what happens in practice is that decisions like enrollment and so forth would happen when there has been a meeting of all stakeholders to discuss that matter, and when there is a consensus that the matter must be enrolled. But my advisory role is where there are issues of that affect the projects, so that we can discuss how we overcome those issues. In relation, for instance, to these specific issues that are raised here at the Commission, there would have been discussions about it to say there are issues that have been raised. There is concerns about these things, you know, and should give that direction to say, no, I'm satisfied about these things. This matter will go on. If there has to be a takedown, the takedown must go on.
You see, from the evidence, say, let's take the Mukwele matter, that it has appearances, even we haven't made any final decisions, but concessions made.
Yeah.
By the witnesses. There seems from those concessions to be an acceptance that there were shortcomings in the investigations. As at least one area, there were shortcomings in the investigations. The question that it prompts for me is, where was the head of investigations when there were these bad shortcomings, these serious shortcomings, and the matter gets J50 issued, people get arrested and they go to court? Where was the head of investigations when this happened, where a poorly investigated case lands at people getting arrested and people getting to court? Even before that, it lands at a decision to prosecute. Now, from your answer, it's still not clear to me that things got that bad because the head of investigation was missing in action for reasons that you give. Or look at the perimeters of my powers, my position. I can't do more than forget that I didn't tell the ID maybe, but if you look at my contract, I can't do more than just saying, ID, this investigation is poor, the matter is not ready to go to court. In the end, she makes the decision, because if that is the case, it may well be that recommendations or thought must be given to how do you give the head of investigations more power, or ensure that in their contract, they get to make determinations about investigations. And they're the ones that sign off to the ID to say, yes, I'm happy with the investigation. And until there is that sign off, the ID may not approve, may not give a decision, or may not sign off. I'm trying to get you, to assist us in answering that kind of question. And I must say that in your answer, the way you've answered, I haven't gotten the kind of assistance that I'm looking for, or the answer to my question.
I understand, Commissioner. The reality of the matter is that this investigation was directed from the ID's office, not from my office. All decisions relating to it were directed from that office, including the takedown. I learned of it after the fact, when in normal circumstances, when you conduct a takedown, we sit in a meeting, discuss how that takedown would look like, whether there's a warrant of arrest to be applied for, or HJ175, all those issues. That was not the case in this specific matter. So it was an unusual situation, and I think that's the best way I can answer you, Commissioner.
Would you consider a as an appropriate suggestion that I put to you, that the system, the structure has to be such that the ID should not be immersed in the investigations, should not be directing investigations, because ultimately her people must satisfy her when she make him her. When they make the decision now, as they're empowered to do, starting with the 2813, right? 2813. The ID should be sitting as a neutral party, so to speak, where others come and persuade her, we need a 2013, and then she can interrogate what they're doing at that point. And then they go and do their work. Now she must authorize an investigation. She should not have been involved in the process of directing, go find this, go find that, because ultimately when they come to her for the, to her in this case, because it was a her, for a 28-1, she must look at it with a fresh eye, with an unbiased eye, if you like. The same for all the various stages that she must authorize. Would you consider it an appropriate suggestion that the ID should in fact be insulated from all of that, so that by the time she's required to exercise the statutory powers of being the ultimate decision maker on the different steps, she looks at things with a new eye and an unaffected eye?
Commissioner, I agree totally. In fact, most of our matters, that's how they have been conducted. She would come at the very tail end. And as I said, that when those meetings happen to discuss where now the team says the matter, the investigation is complete, now we're ready to enroll. And that's how in most matters it would have happened, except for this one.
Maybe the exception suggests that it should be an entrenched position in respect of which no ID has an option to deviate, and there's no exceptional matters, because all matters that come to IDEC must meet the criteria, so they cannot be exceptional and sensitive matters that only the ID should look at.
That is correct, Commissioner, and that's what motivated me to create the case intake criteria.
Okay. Part of the concern you have raised, or an explanation that you have given for not escalating things to the NDPP, you shrugged your shoulders, and we've had evidence as well that where matters have been escalated to the then NDPP, there was no good outcome out of it, and people seem to have ended up in worse positions than they were before they lodged the complaint. How do you suggest to fix for that kind of problem? Is it again a matter of, well, it's about the integrity of the people that you appoint, or it's a problem in this scheme that we have, where you have IDEC falling under the NPA, and ultimately the NDPP is the one that people must escalate things, but the NDPP has a working relationship with the ID because they all belong to the same organization. Is that the problem? And does, in your view, the appointment of the judge, IDEC judge, and whatever his terms of reference are, create a different playing field than what you had when it was just ID and NDPP?
Commissioners, I think, unfortunately, the issue of the judge came much later, even though it was provided for in the legislation. I think it took time to be implemented. I would venture to say that had it been in place much earlier, some of these issues would have been raised with the office of the judge, and maybe there would have been interventions much earlier.
Do you say that because the terms of reference of the judge?
Yes.
Okay.
Remember, the judge would look at complaints even by IDEC staff, political interference, whatever complaints they might have in relation to how IDEC is run, and of course even public about the work of IDEC. So I think people would have felt even more empowered to take the matters to the IDEC judge.
Thank you.
We are left with only, subject of course to whether there are other issues you wish to raise, Ms. Bowe. We are basically left with one page.
Chair, perhaps can the witness read into the record the remainder of his statement?
Yes.
And that way what can remain, if any, after the Sorry, Chair. The look that you gave, I wasn't sure. But
No, please, please don't, I don't want to mention the council's name, but don't play that on me.
No, man.
He always tries to read my face and make conclusions.
No, I withdraw the remark, Chair, that perhaps what will remain will be a couple of clarity-seeking questions and some probative questions on some of the aspects of other witnesses' evidence.
Thank you, Ms. Bowe. Can you please conclude reading your statement then?
Thanks, Chair.
Yes.
I consider it important that the Commission should not conclude that IDEC is, as an institution, compromised. IDEC has sound structures, capable and committed people, and good processes. There is a lot of work that has been done by IDEC colleagues, at IDEC, which shows how committed they are to the fight against corruption.
You left out good. There is a lot of good work.
There's a lot of good work that has been done by colleagues at IDEC, which shows how committed they are to the fight against corruption. I would like to refer the Commission to the infographic marked Annexure MS-13, which gives a summary of matters dealt with by IDEC as they relate to state capture. My evidence concerns the manner in which a particular set of matters was handled, which in my view was an outlier and not the institution as a whole. For the reasons set out above, I recommend that the intake and selection process contained in the operational manual and case selection criteria be fully operationalized, including a single designated intake point and case intake committee. That process was designed precisely to guard against difficulties that have arisen, to ensure that case selection is objective, auditable, and defensible, and to insulate the ID from allegations of targeting or selecting cases without proper basis. Had this been operationalized, many of the concerns I have described would have been avoided. I make this statement in order to place my account of these matters and of IDEC processes before the Commission.
Mr. Soko, there in paragraph 66, you talk about operationalizing the manual. Don't you need more than just operationalizing it? Because that's quite a soft position to take, and it's still subject to human conduct. You can get another ID who simply ignores it. Isn't the solution that it becomes part of the set of documents which are policies and protocols, and if you don't comply, there will be consequences? Because as matters stand, I understood from an earlier discussion that there doesn't seem to be any repercussions for non-compliance with the manual. But if you do have repercussions, be it disciplinary action, it doesn't necessarily have to be criminal prosecution, but if you treat it as part of your policy documents or protocols, whatever name you give it, and it's clear that if you don't comply, isn't that the position you should be advocating for?
I would agree, Commissioner, that
Yes.
I think the manual as it stands is not strong enough in that area in terms of consequences. And I think already, as I said, that there are discussions about it, that there must be an improvement to it so that everyone complies with its provisions without exception.
And there's consequence.
And there's consequences.
If you don't comply.
Yes.
Okay, all right. And then lastly from me, in paragraph 65, you say, my evidence, at the end, you say, my evidence concerns the manner in which a particular set of matters was handled, which in my view was an outlier and not the institution as a whole. I must confess that I'm outside IDEC, but the bit that we have had from other witnesses, I would be very cautious, and I think I would suggest you are too, being inside as head of investigations, about how far this, which you call an outlier, goes. You know, we have become aware of crime intelligence matters because General Mkhwanazi held a media conference. It resulted in a commission of inquiry. The question that I would ask is, well, how far does this go? You know, what else are you not aware of? For example, you haven't spoken to what Mr. Rapesu testified to, that there's an investigation about a 50 million rand that was supposed to be taken by General Lushaba, and he says when he called you about it, you didn't know anything about it. So you do have an idea of what's happening, but maybe in fact the reset that IDEC is doing should include a real deep inquiry into how far does this go? Well, what else was being investigated? Because that's a question that I ask myself as a commissioner, that we've had evidence here, but what else was being investigated off the books that you will not find on record of crime intelligence? What else was the ID involved with? What was Mr. Perumal involved with other than what we now know? So my suggestion would be to be cautious about, well, what we know is the outlier. Maybe it's worse than that. And until you have satisfied yourselves that this is all there was that has come out of the commission, you should be more cautious with that statement. I think there is cause to be concerned. How bad is it? Is this all that we have seen and that's the end of it? I have no reason as I sit here to think that's all there is.
And I understand, Commissioner, from your own position. I'm speaking from what I understand from inside. As I said that there are 137 matters representing 88% of our work, which I believe may not be tainted by these issues. So my statement of an outlier stems from that. It doesn't take away the fact that we have to review. There's an agreement within the organization that we have to review all our matters and be sure that there is nothing that we've missed. And if there's injustice that would have happened, it's corrected. That's the position of the NDPP, that's the position of the leadership.
Thank you. Thank you, Chair.
Mr. Sisoko, before this last engagement by Commissioner Baloyi, my co-commissioner engaged you on what you consider to be necessary, and there was a discussion on policies and how strong the wording of that is, in particular with regard to consequences. I just want your comment on this. I have no idea what we will recommend in the end. It may either be a continuation of an institution called IDEC, or it may be a totally different institution. I do not know. Or the killing of any such institution altogether. But on the assumption that something similar to IDEC, where depending on the acceptance of our recommendations to continue to exist, don't you think it would be better if the processes would actually get legal force from an act, whether it's the NPA Act or whatever other act? So the act itself specifically provides that such a process document should be created, and having its force from an act of parliament, it would be less likely that it would be flouted at whim or at will by whoever the head will be. Of course, human beings being what they are, they will flight laws, which is why, for example, we have criminal trials all the time. We have administrative challenges against state functionaries, and so they will flout the law. But I think it will give more force to have it provided for by the act itself, and not officials sitting down, crafting their own document as they please and of their own accord. What's your comment on that?
Chair, my comment is that I think it will be a good idea that IDEC will have operational regulations. In my previous environment in IPIT, that's what we did once, because I was involved in the development of that IPIT Act. But we ensured that there are also regulations regulating the operations. So once they have the force of regulation, then it enforces all these issues that we spoke about.
And is it the act itself that says there must be
a regulation,
all right,
which talks to the operations?
Yeah. It's exactly something similar that I have in mind.
Yes.
Depending, of course, as I say, on what our ultimate recommendations are with regard to IDEC. Yeah.
Chair, I assume we agreed that
the lunch
that we
adjournment.
take the lunch adjournment.
All right. And let's adjourn and come back at 2:15. Let's adjourn.